Again, welcome to our virtual audience and those who have joined us in person. And for those joining us from home, you can put your questions in the Q&A. We will have time at the end for them. And like I said, we are so excited to be hosting these events in partnership with the Wheaton League of Women Voters. And I am so pleased to have the honor to introduce our guest speaker, Professor Steve Schwinn. Professor Schwinn teaches at University of Illinois Chicago Law School and is active in the community. He litigates cases pro bono in the federal courts. He works with area school teachers, students, and nonprofits on outreach and public education related to the Constitution. And he serves on the board of advisors for the Chicago Lawyers chapter of the American Constitution Society and the American Bar Association Standing Committee on Public Education. We are so lucky to have Steve back with us once again and to give us an update on the major issues before the Supreme Court. Let's give a round of applause for Professor Steve Schwinn.
Hey, everybody. Thank you. Can you all hear me okay? Yeah. Okay. So, and if online, if you're having any trouble with audio, with video, anything like that, please just let us know and we can take care of it. So Steve Schwinn, I know many of you and have seen many or all of you at previous functions. I tell Barb that this is my favorite event every year. I just love engaging with you about what's going on at the Supreme Court, and so much to talk about, right? Crazy stuff. So much to talk about. I teach constitutional law, comparative constitutional law, and human rights at UIC Law School in Chicago, and do civics awareness, civics engagement, civics education type events like this. But again, as I tell Barb every year, this is by far my favorite. And I gotta say one thing. What so excites me about being with this group in particular, and I just told Barb this, I think for the third time tonight, is that you all are so sharp and engaged and your questions are so thoughtful and insightful. So I look forward to taking them tonight. What I thought we'd do is talk a little bit about what's going on at the court, but as we go, if you have questions, please just pipe in. Because we're doing the mic thing, maybe raise your hand so that we can get you the mic to ask the question so that those online can hear. And for our friends online, if you have any questions, please feel free to just drop them in the chat and we'll be sure to get to them. Sound good? All right. So I want to thank you all. Thanks to our friends at the Wheaton Public Library. This is fantastic. I appreciate your support. And with that, what do you say we get going? So we're here to talk about the Supreme Court tonight, and I think we need to talk about the Supreme Court, but it does occur to me, I don't know, that there might be other things going on in the news touching on constitutional law and civics issues. If you would like to spend some time talking about that, or if you have any questions about that elephant in the room, we can certainly do that. And I'd be happy to do that now or later. And then maybe what I'll do is just pause and see if anybody has any thoughts on that, or if you would like to talk about that big issue. If you don't know what I'm talking about, the Trump indictment. Do you have any questions? Yeah. Oh, I'm sorry. I spaced on that. My bad.
What happens if they drag this out, through the 2024 election?
That's a really good question. And I think it's a really hard question. I also think it's a very plausible question, right? Former President Trump's MO is to drag things out as long as he can. We saw this time and time again in the Trump administration and after the Trump administration. And I think we're going to see it in this litigation. And there are a lot of opportunities for him to do that. So we're going to start to move into criminal pretrial practice, which will involve a period of discovery where the prosecution provides evidence to the defense. The defense will probably file a round of motions to dismiss all or some of the charges, maybe on some other grounds as well. All of these will take a great deal of time. And let me just tell you, after watching the Trump administration, when President Trump was in office, what he did was not only drag his feet, but raise what were often, I'll say novel, but what I mean by that is spurious claims before the courts that tied up the courts for months and years, ruling on things that sort of everybody knew what the answer was going into it. The whole point was just to tie things up. And so if he starts to file a round of motions in the criminal case the way he did when he was in office, I expect the exact same thing to happen. Many of these issues could go all the way to the Supreme Court, which could conceivably take months and years, bringing us into the 2024 election. Now, if that happens, there are a couple of things we want to keep our eye on. Number one, the Justice Department has a long-standing position that it will not prosecute a sitting president. The theory behind this is that the sitting president sits atop of the executive branch. If the executive branch does anything, it's enforce the law, right? That's sort of the quintessential function of the executive. And so the executive gets to call the shots with regard to which laws are enforced and how, which means that the executive can't be prosecuted. Now, there's another reason too that overlaps with one of the other themes I want to talk about tonight with regard to the Supreme Court. The idea here is that prosecuting a sitting president would incapacitate the single person who sits atop one of our branches of government. And by incapacitating that person, you've effectively incapacitated that branch of government, right? And so the theory between those two ideas is that the Justice Department won't prosecute a sitting president. Now, that much we know with regard to the Justice Department's longstanding position. Now, whether those claims would hold up in court, that's a different question. They've never been tested, thank goodness, but that's their position. Now, the question then is, how far does that principle, do those principles extend, right? Would that insulate a candidate for office from prosecution? Would that insulate the leading candidate of one of the leading political parties from prosecution during the campaign? Those questions we just don't have answers to. And so if the Department of Justice would at some point drop its prosecution because it looked like Trump was the front runner for the Republican Party, I don't really know, quite frankly. We just don't know because we've never been there. There's a good argument that they ought to, but there are equally good arguments that they ought not, and we just don't know. Now, if President Trump were to drag this out past the election, and if he were elected to office, then there are a number of interesting things that could come up, as always with Trump. The number of interesting things that have come up with Trump over the last, what's it been now, 7 years, are just dizzying. But this would be yet another interesting thing. And that would be, could he be prosecuted as a sitting president? The Department of Justice would say no, and he would certainly install people at DOJ that would drop the prosecution. But even if the prosecution had gone forward, even if, say, he were convicted and appealing his conviction while getting elected to the presidency, what could he do about that, right? Well, there's a serious question about whether the president could pardon themselves. That's an interesting question, isn't it? Could the president pardon themselves? Now, we might not even have to go that far, because there's an interesting way that the president effectively could pardon themselves without pardoning themselves. Suppose that Trump were elected, right? And he'd been convicted, he's on appeal. Now what he does is instruct his vice president to pardon him, resign from office, the vice president becomes president, the vice president then pardons Trump, and then the vice president resigns and Trump is reinstalled as the president. Now that's whack, right? Like, that's just totally bananas, but that's the kind of world that we're living in, that we even have conversations like this. I mean, all of this is just so far off the charts with what we've considered in our politics and constitution. We really have no idea. So it's kind of a long-winded way of saying, I don't know, right? But there are a lot of really interesting and important questions that come up dealing with the separation of powers, how our Constitution works, what our elections mean, democratic accountability, all of those good things. Yeah, I think it's a real possibility. And if it were to happen, we're just yet again in uncharted territory. Yes.
Liz.
Oh, I'm sorry. I don't understand why he could take over I don't understand why he could take over after he'd already resigned.
Well, that would be a problem with that theory, yes.
Yeah.
So that could present a problem, but remember, right? Like if that's like, what about all this other stuff that preceded that? I mean, we've got a lot of really weird stuff that would have to come down before we even got to that point. And again, we're just in totally uncharted territory. This is the first time a former president has been indicted and charged for a federal crime. Like this is really big stuff. I've got a couple of young people in my household, one who's going to be a senior in college, the other is going to be a freshman in college. And I try to impress upon them just how utterly extraordinary this is. And they're like, yeah, you know, Dad, that's your job. Don't talk to me about it. But these are really extraordinary times we're living in, right? And it's important that we acknowledge that.
Wasn't this though almost where we were at with Spiro Agnew and Richard Nixon, that Nixon
Yeah.
was possibly going to be losing office and then Agnew would have become president and he was already under investigation.
And
right?
Agnew went away and then Ford came in.
Yeah.
And then when Nixon resigned, Ford became president.
But
Yeah,
they were facing, right, the dilemma that he could easily have become president while still, okay.
absolutely. Yeah. And the similar kind of musical chairs.
Yeah.
Yes.
And could I ask you just, I'm sorry to hog the microphone. One more was, could you just, I know it's been in the news, but how did the judge who seems to have no experience with, or little experience with trial, get
Yeah.
selected into one of the most important trials in the country? I hear it's random, but it just seems awfully awkwardly
wait.
random.
Okay. Oh, I'm sorry. Okay. Not just any judge, right?
Yeah.
This is the crazy thing. So here's Ellyn Cannon. Remember, she was appointed and confirmed after President Trump lost the 2020 election. Now, just saying that sounds like kind of a crazy thing, but even crazier when you consider that the Senate majority leader, right, at the time, refused to even consider, even give a hearing to Merrick Garland when Obama nominated him to the Supreme Court in, what was it, February before the election, right? Because Obama was in his last year of the presidency. Again, we're just in really weird, uncharted territory. And so now you've got a sitting judge who doesn't have a lot of experience in criminal or civil trials for that matter. She just hasn't been on the bench that long. And happens to draw this case that by coincidence, she had prior involvement in when Trump filed his motion earlier in the litigation when we were at the grand jury stage. How did it end up with her? I've got to kind of believe what the clerk of the court is telling us, and that is they do random assignments in the jurisdiction. As I understand it, there are fewer judges in the Palm Beach courthouse than are in the Southern District generally. And so the probability of her ending up with the case is somewhat greater than is sometimes reported by some people. But nevertheless, a pretty extraordinary coincidence that she would end up with this case. There's some murmuring about whether she ought to disqualify herself or ought to be disqualified either because of her lack of experience or because of her prior involvement. And I'll just give my 2 cents on that. Her lack of experience, I would caution us against urging her to withdraw or having the chief judge in the district ordering her to withdraw based on her lack of experience. I think that would be a bad precedent to set. But with regard to her prior involvement in the case, I don't know if y'all remember this, but Trump had filed a motion in her court while the grand jury proceeding was going on in Washington, D.C. And Trump filed a motion in her court to get a special master appointed to review the documents that he was withholding. Extraordinary. I mean, there was no basis for that lawsuit. And yet she not only accepted the lawsuit, but went ahead and appointed the special master, who then held up the Department of Justice's investigation into the matter. I mean, this is crazy stuff. And she ordered it. And then she got smacked down by the 11th Circuit on a 3-judge panel, 2 of which were appointed by President Trump himself, right? This is just how far out there we are. And so it's not just a little bit of bias that she's demonstrated. It's like it's kind of a lot of bias that she's demonstrated. And I think if anybody's going to get her dismissed from the case, that would be a much stronger basis to do it. Yes. Oh, she did.
She's already entered a scheduling order there's a procedure dealing with confidential documents that each of the lawyers have to follow. So she's entered an order setting a date for them to comply. So that indicates, at least to me, that she's not going to recuse herself. And then going back to your presidential succession issue,
Yeah.
there is a provision in the Constitution for a temporary elevation of the vice president to serve as the president when the president is incapacitated. And doesn't that solve their problem about?
It could, the 25th Amendment. Now that's another thing that we thankfully have not had serious cause to test in any way in our democracy. In theory, it could. Yeah, and you might remember at the end of the Trump administration, some in his own cabinet were talking about invoking the 25th Amendment to get him out of office even before he was scheduled to leave. Yeah, so that would be a possibility. Endlessly fascinating issues, right? I mean, really, it is quite a civics lesson we've endured over the last 7 years and continue to endure. You know, the indictment in the Southern District is not the only one going on. You know, there's an indictment in New York in the state courts. It looks like there's an imminent indictment out of Atlanta for election interference. The special counsel is still investigating Trump's role on January 6th. We don't know what will happen with that. There's a possibility that there might be further federal charges in other federal courts where Trump crimes were committed with regard to these records. So there's a lot of stuff going on out there. In my view, for what it's worth, I think the maybe strongest case against Trump is actually the Atlanta state case for election interference in Atlanta, just because the evidence is so clear, it's on record, there's a tape recording, and there's no federal issue. So none of the stuff that we've been talking about is at issue. If the Department of Justice can't decline to prosecute because they're not prosecuting. It does raise interesting federalism issues and important questions if Trump were to actually run and become the Republican nominee or get elected. There'd be really interesting and hard federalism issues involved, but not the same that we're talking about with the Justice Department prosecution. It's just a different ballgame. So I think that's one to keep an eye on. We'll see what happens. I'm often asked, what do you think about the evidence in the Southern District indictment, the one that came down last week? The evidence is unbelievably strong. Like, you don't see cases like this. It's crazy how airtight this is. That said, you're still relying on 12 jury members that all of which would have to convict. And so, who knows? It really is a crapshoot. You probably have read in the news that, there are half dozen people just in the last decade or so that have been convicted to sentence to jail terms, right? For crimes that pale by comparison with regard to misuse or mishandling of confidential documents or national security secrets. Again, that's very interesting. Will it matter in the end? It's impossible to say. Yeah, a lot of stuff going on. If we want to talk about more about that, I'm happy to at any point. Just chime in, and for our friends online, just add a question. Let's talk a little bit about the court, and I want to talk sort of at a 30,000 foot level, and then we can talk about some specific cases that I think we really ought to be keeping our eyes on. So at a 30,000 foot level, there are a number of things going on. One is Supreme Court ethics, right? We've all been reading about ethical obligations of Supreme Court justices. And as it turns out, the lack of ethical requirements on the part of Supreme Court justices, they're just not there. Now, there are ethical standards for lower federal court judges, but they don't apply to the Supreme Court. When the Supreme Court files its financial disclosure reports, which they recently have done, except for Alito and Thomas, who filed for a delay. When they file that, what they say is they're filing it voluntarily, that they don't have to. There's nothing that requires them to. And what they say is indeed to require them to would be a grave separation of powers violation. The theory is that if Congress were to impose ethical obligations on the Supreme Court, that Congress, remember a few minutes ago, we talked about the idea of the president being the single president, right? And that if the Justice Department were to prosecute the president, it would disable the single head of the executive branch, effectively disabling the executive branch. Well, the same idea applies with regard to congressionally mandated ethical obligations on the Supreme Court. If Congress is able to impose ethical obligations on the Supreme Court, the reasoning goes, then Congress could effectively disable the Supreme Court, the kind of logical extension of that, right? And so the Supreme Court has taken the position, and many have taken the position, that Congress can't impose ethical obligations on the Supreme Court because to do so, if you follow it to its logical extent, could effectively disable the head of the judicial branch of government in the same way that Justice Department prosecution of the president would disable the head of the executive branch. Now, for my money, I got to tell you, I think that's bunk. If you look at the constitutional structure, it turns out that Congress gets to set the pay for Supreme Court justices, gets to set the budget for the Supreme Court and the judiciary. Congress gets to tell the Supreme Court when to sit and where for its cases. It gets to tell the court how it can take cases and how it can't take cases. Congress can, even when a case is pending at the Supreme Court, withdraw jurisdiction from the court over that case that is pending at the Supreme Court, and thus affect the outcome of a case while it's at the court. Congressional authority over the courts is enormous. And for my money, to say that Congress can't impose ethical obligations on a court over which it has that kind of control is just, it's just not right. But that's me. The Supreme Court's taken a very different position, and Congress seems unwilling to test it. And so I don't think we're going to see Supreme Court ethics anytime soon. And, you know, if recent history is any guide, my guess is things are going to get a lot worse before they get better. The second sort of 30,000 foot. Oh, yes, I'm sorry.
Although they have all that power, have you seen them using it lately, or they request the budget, they get the budget?
Yeah, no, I'm so glad you asked that question. I'm going to get wonky here for a second, if I haven't been already. I'll say wonky because that's better than saying nerdy, but really I mean nerdy. So I've been doing some work the last couple of years on a couple of cases where Congress has effectively directed the outcome of current cases in the courts, and the Supreme Court has upheld the congressional law. One case in particular, Congress effectively directed the outcome in a case brought by families of terrorist victims who were seeking compensation from the National Bank of Iran. And Congress stepped in and wrote legislation that didn't literally say in this case, the plaintiffs should win, but it effectively said that and effectively directed the result of the litigation. The case went to the Supreme Court on separation of powers grounds, saying that Congress can't do that because it interferes with the court's ability to decide cases and controversies under Article 3 of the Constitution. And the Supreme Court upheld it. Stunning to me. The Supreme Court has similarly upheld a lot of different congressional law that restricts the court in one way or another in doing its job. We'll talk about one case here in just a second. In voting rights litigation, as you might know, is ordinarily heard at the district court level by a 3-judge panel. Appeals of those decisions get a fast track to the Supreme Court. Why? Well, not because the court said so, because Congress said so, and puts it on a different track. That's the kind of power that Congress has. And, you know, not only is it the case that nobody questions that power, but the Supreme Court itself upholds that power. And so again, for the court itself to kind of fall back on separation of powers and say, hey, don't get into our Article 3 business, seems a little out of alignment to me. Yeah, but again, that's me. So another issue at 30,000 feet I want to talk about is just the alignments on the court and some of the weird politics that we're seeing. So, you know, with the addition of Justices Kavanaugh and Gorsuch and Barrett, we've seen a sharp turn to the right on the court. We saw that last year in the Bruin case. We saw it in the Dobbs case, the abortion case, the Second Amendment rights case. We saw it in the court's rulings on religion last summer, and we saw it in the court's rulings on the Clean Air Act. And we'll talk a little bit about the Clean Water Act tonight, but the Clean Air Act last term. And so sharp turn to the political right on the part of the court. What that means is the median justice has kind of changed, right? And it looks right now that we're seeing some interesting moves by Chief Justice Roberts and Justice Kavanaugh. I just want to be clear, no political progressives, right? These are not liberals, right? And they're at the center of the court these days. And we're actually seeing them in some interesting cases align with the progressive justices on the court to come up with some alignments that are quite frankly head scratching. I've got some theories on this that I'll share with you, but we're seeing some really kind of weird alignments on the court to do some very unusual things and surprising things, one of which we'll talk about here in a second. Yeah.
So on that point, so like the voting rights case for Alabama, you know, I'm wondering, do you think that they, you know, upheld Section 2 because they saw the low approval ratings that they're getting and because of a presidential election, and that maybe they wouldn't have done that had the approval ratings been higher and it wasn't coming up on a presidential election? I mean, do you think they really are the center, or they're just playing politics?
Well, I don't know, but that you've articulated my theory better than I could. Yeah. Yeah, I mean, nailed it as far as I'm concerned. I think that must be going on. And I do want to talk in detail about that case and give you a little bit of history, or at least remind you of the history kind of leading up to this Section 2 case this just last week, right? And try to unravel what's going on in that decision, because it really is confusing and surprising. For our friends online, this is not guitar lessons. And let me assure you, you will be gravely disappointed if you came here for guitar lessons. So just on the Section 2 case, and again, I want to take a deep dive into that in a second, but there's something else going on here that we saw in that case, and we're seeing in a number of different cases, and that is really aggressive moves on the part of challengers in a lot of different ways. We see it in the Section 2 case where Alabama put front and center before the Supreme Court just a sea change in the way the court would analyze Section 2 voting rights claims in the context of redistricting. Just a total 180-degree change. And what was surprising in that case is the court rejected it. Now, there are other cases where litigants are putting forward equally aggressive claims, and it looks like the court's going to accept those claims. I'm thinking here of the affirmative action cases and the 303 creative case, if you're familiar with that. If not, we'll talk about it tonight. But I think we're going to see some dramatic changes in that regard. We want to talk about what the court's doing, of course, but what's striking to me is that the litigants are putting forward these really, sounds like I'm exaggerating, but I'm really not, breathtaking claims of changing the law to the court, I think in the hopes that they can get a majority or even a super majority on the court to just turn the law in an entirely different direction. We saw that last summer, right? I think Dobbs, the abortion rights case, is the clearest example of that, where litigants for a long time have been putting up theories to overturn Roe versus Wade. And finally, they got a majority on the court to do it, and the court did it, right? Similar kind of move in the gun rights case in Bruin, definitely same kind of move in the religion cases last summer and in the environmental case last summer. We're seeing similar kinds of moves now. What's interesting to me is that we're seeing these, but also the way the court's dealing with them. And so in the Section 2 litigation, the court said, no, Alabama, we're not having any of that, right? You're just wrong. We're not going in that direction. And I think your theory has got to at least be a partial explanation, if not a full one. Yeah, I think what's happening is that the court recognizes that it went a little too far last summer and that it's pulling back a little bit, maybe in anticipation of what many, I think, are going to think is the court going too far with the abortion case, which should be coming down potentially tomorrow, and 303 creative, and a couple of other cases that are out there that are going to take us again in very different directions than we've been. So interesting times to talk about constitutional law for a lot of different reasons and what's going on at the court. I guess let me just pause for a second. Oh, one more thing I want to mention, Justice Jackson. You know, it's said that every time a new justice joins the court, it becomes a new court. Justice Ketanji Brown Jackson joined the court and has made her voice heard. It's actually really something to watch. And if you haven't had a chance to listen to some of the oral arguments, I urge you to do that and listen to her questioning. It's very good, very probing, incisive questioning that in some ways kind of cuts right to the chase and to the point. I'm thinking particularly about her questioning in some of the cases that we'll talk about tonight, the affirmative action cases, the Section 2 case in the voting rights. If you haven't had a chance to listen to those arguments, they're kind of long, but if you're out on a long walk or something, or you just want to put yourself to sleep, I don't know, you could listen to them. So what I did in preparation for tonight is try to put the cases in a couple of buckets that I thought would be interesting. And so the buckets I came up with are voting rights, race, environmental protection. And environmental protection here, I think, sweeps broader than just environmental protection to general regulatory authority of federal government agencies, which I think is important, but it's coming up in the context of environmental protection. Speech and discrimination, the 303 creative case that I mentioned, and then what I think we can dryly call separation of powers, but really these are not at all dry cases. So we're talking about everything from immigration enforcement to student loan forgiveness to the Indian Child Welfare Act. And I thought what we might do is just kind of march through those and see how far we get. If you want to jump from one to another, I'm happy to do that. If you have questions along the way or comments along the way, please, let's have a conversation. Does that work? You want to start with voting rights? We are the League of Women Voters after all. Yeah. Okay, so let's pick up on the Alabama case and this Section 2 case of the Voting Rights Act. I don't want to bore you, so I'm going to ask, would it be useful to know a little context and history, or do you feel like you got that? Context and history. Okay, so Voting Rights Act, 1965. I'm not going to go all the way that back, but I do want to describe the structure for you, because the structure of the Voting Rights Act, I think it informs what the court's doing and helps us understand the significance and magnitude of the moves of the court. So there are two key provisions that we want to keep our eye on in the Voting Rights Act. The first one is really kind of easy to understand. It says that the government can't discriminate by race in the right to vote. Okay, it's really that easy. This is Section 2 of the Voting Rights Act. Now we'll talk about what discrimination means here in a second, but it's enough to know that the government can't discriminate by race in the right to vote. Now, if you think about that for a second and think about all the different voting practices and restrictions that we've seen over the last decade or two, right? It's pretty easy to see that states can discriminate by race in the right to vote without overtly discriminating by race in the right to vote, right? Just a very simple example. Voter ID in many locations around the country highly correlates with race, and requiring certain voter identification effectively disenfranchises or makes it much more difficult for people of color to vote. And so a voter ID law on its face isn't race-based, but nevertheless has this racial effect or impact. And so Section 2 would apply to that kind of situation. It would also apply to a kind of situation where an election official outright denies the right to vote of a Black voter, for example, right? And that's pretty easy to see. But because so much of these practices can kind of fly under the radar in the sense that they're racially neutral practices, right? What the Congress said in 1965 is we need to complement Section 2 with the second section, important section of the Voting Rights Act, Section 5, which we'll call the pre-clearance provision. This is innovative is an understatement, innovative way to enforce voting rights. What Congress said is, look, if Section 2 isn't doing its job, and it can't do its job because so much of these practices fly under the radar screen, but for the other related reason that by the time you get through litigation for a voting practice under Section 2, the election's already happened. And you can't put that toothpaste back in the tube, right? It's done, it's over. You might win, but you don't win. And so Congress said in 1965, we're going to require that states and local jurisdictions that have a particularly ugly history of racial discrimination in the vote, we're going to require those jurisdictions to get permission before they make any changes to their voting practices, any changes whatsoever to their voting practices. They have to get permission from a 3-judge court or from the Department of Justice. And what that court or the department is going to determine is whether the voting change would have what we call a retrogressive effect on minority voting rights. It would be a setback for minority voting rights. If so, then the 3-judge court or the Department of Justice would deny pre-clearance for that change, and the jurisdiction could not make that change. Now, for a long, long time, both Section 2 and Section 5, actually going back all the way to 1965, both of these provisions under the Voting Rights Act have been under attack by opponents of the Voting Rights Act. The argument that they've made is that Congress lacks authority to enforce these provisions, to create these provisions in the first place, because under the 14th and 15th Amendments, Congress is not enforcing the provisions of those amendments. And so that actually may require a footnote. When Congress goes out and legislates, it doesn't just kind of do what it wants to do. It has to have a constitutional source for its action. It has to have a specific constitutional authority for the action it takes. I know sometimes we think, well, Congress is just doing what it wants to do. Yeah, kind of. But if it's tested in court, Congress needs to articulate a constitutional basis for the authority that it's asserting. And here the authority would be in the 14th and 15th Amendments, the Equal Protection Clause and the 15th Amendment's prohibition on racial discrimination. So the opponents of Section 2 and Section 5 have long argued that Congress, by enacting Sections 2 and Section 5, it's not enforcing equal protection. And it's not enforcing anti-race discrimination. It's going beyond that. It's going, in other words, it's kind of going beyond the powers that it has in the 14th and 15th Amendments. It's kind of a technical argument, but it's important to understand what opponents are arguing in the courts. Now, up until 2013, the courts had flatly rejected these arguments and said Congress clearly has authority to do this. They plainly do. No questions asked. Congress can do it. In 2013, a jurisdiction called Shelby County in Alabama challenged the preclearance provision, Section 5 of the Voting Rights Act, saying that it exceeded Congress's authority to enforce equal protection norms under the 14th Amendment. And in 2013, the Supreme Court agreed. What the Supreme Court said as a technical matter is that Congress kind of missed the target when it identified those jurisdictions that have an ugly history of vote discrimination. That preclearance could still be on the books in theory, but there was no coverage because no jurisdictions fell within preclearance. And Congress has not been able to muster the votes to rejigger their formula. And so preclearance is a dead letter these days. When Chief Justice Roberts wrote that opinion, there were a lot of things in the opinion that he wrote, but one of the things was, look, things have changed in the South. Literally, he wrote those words, things have changed in the South. The discrimination today is nothing like what it was in 1965. And so we don't need Section 5 in these jurisdictions anymore. I know for our audience on Zoom, there are audible groans that may not, I'm not sure that's coming across in the closed captioning, but that's what's going on. Another thing that he said is, look, to the extent that there's race discrimination in the vote, Section 5 goes away. So what? Section 2 will pick up the slack and do the job of restricting discrimination in the vote, right? Okay, well, wouldn't you know, just a couple of years later in 2021, the Supreme Court limits Section 2, dramatically cutting back on Section 2 actions. And here it might be worth just me describing how they did this. There were a couple of voting practices in Arizona that were challenged as violating Section 2 of the Voting Rights Act, that they had the effect of discriminating by race in the vote, right? And what the Supreme Court said was, no, they don't violate Section 2. And by the way that we've been evaluating Section 2 all these years, it's wrong. We need to evaluate it in a different way, using a kind of factors approach, looking at different factors. One of the factors the court looked at was the state of voting rights in the early 1980s, 1982. And the reason the court did that is because Section 2 was amended in 1982. And the court said, we're going to use 1982 as our benchmark for what voting rights ought to be. Now, think about that for a second. How far our voting technology and voting opportunities have increased since the early 1980s, right? What that means is, if a jurisdiction increases voting access and voting rights since 1982, it can now restrict those as much as it wants all the way back to the 1982 benchmark. Stunning. So if a jurisdiction in 1982 was not doing drop box voting, but today it is, well, it can withdraw drop box voting, even if that has a racially discriminatory impact on racial minority voters, because the benchmark is what the jurisdiction offered in 1982. That's stunning, isn't it? Stunning. A sharp blow to Section 2. Now, why do I say all this? Because the Supreme Court has been on a tear for 10 years now to restrict the Voting Rights Act in these two key ways. But there was one wee bit portion of it that still maintained its full vitality. And that is Section 2 challenges, not to ordinary voting practices like drop boxes, but Section 2 challenges to redistricting. So, you know, every 10 years we do the census, and every 10 years state legislatures draw new legislative boundaries for their own state legislatures and for their congressional seats. Alabama redrew its districts in 2020 based on the 2020 census, and it carved up its state into its 7 electoral districts. The state is about 27% Black. And yet the Alabama state legislature gave a majority black district in only one district, right? Whereas the numbers would suggest two. Now, the thing about Alabama is there's a band in Alabama, geographic band that they call the Black Belt, not because black people live there, although they do, but because of the fertile black soil. Now, it is heavily populated by black people, right? But it's also, they're in two major population centers with a kind of belt between, and pretty easily divisible into two congressional districts. And by the numbers, that's what you would expect if you were divvying up the state on a statewide racial basis. But that's not at all what Alabama did. Instead, what the legislature did was to crack those majority black districts, that is to kind of break them up to ensure that black voters remained a minority in predominantly white districts, and then to pack black voters at a disproportionate rate at 60% into a single district so that that district can elect in the language of the Voting Rights Act, a candidate of their choice, but do so by a supermajority. And so in election law speak, there's essentially a 9% wasted vote in that district, right? Because it's 60% black. Now, in a place like Alabama, maybe it goes without saying, but I'm going to say it anyway. We're assuming that people are voting by their race, right? The sad truth is, in a place like Alabama, they largely do. And that's why all of this is relevant. So advocates challenged the legislative map that Alabama drew under Section 2 of the Voting Rights Act, which you can do. And again, this portion of Section 2 apparently maintained its full vitality even after that Arizona case that I described a second ago. The way Section 2 litigation works in the context of districting, and again, this is a little wonky, but what the courts do is they look at what they call a totality of the circumstances approach. They look at kind of the entire context of the legislature drawing its map to understand whether the legislature actually drew it with racial intent or not. Now, the problem is the legislature itself isn't standing up and saying, yeah, we're doing this by race. So sadly, sometimes they do. In fact, too often they do. But this test is designed for when they don't, which they often don't, right? They know what they're doing, but they're not saying it. And so the test is designed to kind of smoke that kind of practice out. Part of the test requires a challenger to come forward with an alternative legislative map to demonstrate that the legislature could have drawn a map, in Alabama's case, with an additional majority black district, right? Now, that was easy to do in this case because it was right there, plain as day, if you looked at Alabama's map with a racial overlay. It was actually really, really super easy to do. And so that's what the advocates did. Alabama came back and they said, ready for this? Alabama came back and said, well, they can't do that because that's racial discrimination. You can't demonstrate racial discrimination by using race because by using race is racial discrimination. What? Now, Alabama was not, they had a little help from the Supreme Court here in a completely different line of cases involving school desegregation, where Chief Justice Roberts for the court rejected a school desegregation plan that was based on race with this line: the way to stop discrimination by race is to stop discriminating by race. Right. And so Alabama thought, well, hey, if that's what anti-discrimination means, you can never use race, we have to be racially blind. Well, then that means that nobody can prove that we were discriminating because one would have to use race to do that. Right. What Alabama here was pitching is a racially blind view of equal protection and the 15th Amendment and the Voting Rights Act itself. And they were completely upfront about this in their briefing and at oral argument to the Supreme Court, and with good reason. They thought they had the Chief Justice in their pocket, right? And certainly a majority of this court in their pocket. That language I quoted to you a second ago, it's from a case over 10 years ago. Things have changed a lot in the court since then. So they thought they were on safe ground. The court, in a decision last week, flatly rejected that theory. It was the weirdest thing. The court came down and said, no, look, we have a long line of decisions. We're relying on our precedent here, and we reject Alabama's racially blind approach to Section 2 enforcement in the context of redistricting. Chief Justice Roberts and Justice Kavanaugh joined the three progressives on the court for that holding. It was stunning. A lot of different theories floating around out there about why. I tend to think that Chief Justice Roberts, and maybe Kavanaugh too, saw the court as moving a little too fast, a little too far, and decided to put the brakes on in this area in order to signal that, you know, they were not completely changing the law. Now, what's interesting about the case is Alabama now has to redraw its districts with the second majority Black district, which almost surely means that the Alabama congressional delegation will now include an additional Democrat, just because of the way people vote in Alabama, which will have implications on control and leadership in the House, but not just Alabama. By some people's count, this ruling could require enough other states to change their electoral districts that it actually would have changed control of the House after the 2020 election. That's something, isn't it? Now, what will that mean in 2024? I have no idea, right? Where we'll be in a completely different political environment. But if states have to go back and change their electoral maps, you know, we're likely to see at least one more Democrat elected from Alabama, and probably from some other states as well. So really interesting political implications of all of that. That's a big one. There's another really big voting rights case. Who is this a big one? But before I do that, do y'all have any questions or comments on the Section 2 litigation? Yeah.
So would the districting in these other states have to be challenged in court before they would have to do the
Technically
redistricting? So
speaking,
challenges would have to come forth in every state?
they are. Now, some of those are already in the pipeline. And so the lower courts are going to read this Supreme Court case and say, the law is the same that we thought that it was. And so we're going to apply it and strike the state's electoral map. And so things could happen sooner than initiating litigation. But yeah, they're going to have to go through their own courses. These cases, as you can imagine, are just so fact specific, right? What happens in the halls of the Alabama legislature is very, very different than what happens in the halls of the Louisiana legislature. And so that's why this totality of the circumstances approach is so important. These cases regularly run 100, 150 pages in length, just because the courts have to go through so much evidence in trying to determine whether there was racial intent. Other questions or comments? Yes, ma'am.
So I have a plan. Okay, so you know how all these reforms, Supreme Court reforms, have been shot down as they're not going to happen. It's going to be very, very difficult to do term limits, to do the ethics, to do even if, you know, all these kinds of things, expanding the court, whatever. So if the theory is correct that the Supreme Court is upset at its low approval rating in an election year, would it, and maybe you could tell me, has this ever happened historically? Would a letter writing campaign to the Supreme Court, like I write tons of letters to the editor. The first one I wrote to the Supreme Court was just recently. It was scathing. And so if say a certain organization that had representation in all 50 states started flooding the Supreme Court with angry letters that they're illegitimate and that they are not they are moving to the right of what the American populace wants and therefore being un-American and undemocratic, do you think that that would have an influence?
You've just heard from Mrs. Katie Staten, a little rebel.
Wow, that opens up a lot of different ideas. Short answer, yes, I do. And I think that that's a worthwhile pursuit. What we're seeing, and people in my field are saying more and more, that the court is a political animal, just like Congress, just like the president, and that we need to stop pretending that it's not, and that they are susceptible to public pressure. One thing Chief Justice Roberts said recently that I thought was really interesting is the hardest decision that he had to make, he said, while he'd been on the court, was putting up the fence around the court when the Dobbs decision was coming down. Now, I think there's a lot to unpack there, but what that tells me is that they're not immune to what's going on in the real world, that they're paying attention. I'll give you another anecdote. A friend of mine years and years ago, she wrote a handwritten note to each of the justices with a law review article that she had published that was pertinent to a case that was then before the court. And when she told me she did this, I thought she was crazy. She actually got several handwritten notes back from the justices. Yeah. I never would have expected that. I mean, I think they pay attention. So yeah, go for it. The second election case is it's kind of equally nerdy, so bear with me here for a second, but its implications are so important that I think it's worth it. Let's start with what happened in the case. In North Carolina, the state legislature gerrymandered its districts. The allegation wasn't that they did it by race, but that they did it by politics, political gerrymandering, right? Everybody does this. But they did it to such a degree, the claim was that the political gerrymander violated the state constitution, okay? The state constitution has a number of provisions about things like equal voting power, equal representation, Republican form of government, small r Republican form of government, that kind of thing. And so the challengers said, look, we can't litigate this under the federal constitution. The Supreme Court has said those cases are non-justiciable. We just won't hear those cases. But we can litigate it under the state constitution in state court. And so they were very careful in the way they pleaded the case and said this is a state constitutional violation, no federal constitutional claim. And the state Supreme Court said, you're right, this gerrymander violates the state constitution. Okay, let's think of that as step one. Now, at that point, members of the state legislature who drew the map got really upset, right? Because the state Supreme Court struck their map. And so they sued, not in state court, but in federal court, arguing that the North Carolina Supreme Court decision violated the federal constitution. You might think, well, what, how, why, right? And why wasn't that litigated below? Well, here's why. What they said was that the federal constitution has a clause in it called the elections clause that gives to, and here I'm going to use air quotes because it's from the constitution, the legislature of the states, the power to run elections, except that Congress can step in if it wants to and designate the time, place, and manner of elections. Or in other words, ordinarily the state legislature is responsible for setting the rules of elections, but if Congress wants to step in and do it, Congress can. The theory here was that the Supreme Court, by overturning the state legislature's election map, had interfered with the legislature's power to set the election rules in the state, right? Now, you might think, well, that sounds like a hyper-technical reading of the legislature. Didn't the framers actually mean the lawmaking apparatus of the state, which would include the governor's signature, judicial review by state courts, right? All the trimmings, all the things that kind of come with lawmaking. Well, that's not their theory. Their theory is, no, the legislature and the legislature alone gets to set these rules. This theory is called the independent state legislature theory, ISL. The claim is that the legislature is all powerful with regard to election rules in the state, and that the state Supreme Court, the state governor, the state attorney general, the state voters themselves cannot change that. It belongs to the legislature itself. Okay. Now, I want to finish out the story about North Carolina, and then I'm going to tell you the significance of all of this. So in North Carolina, if you were following this, you know that the Supreme Court turned over in the last election. They have an elected Supreme Court, and it went in the other direction. And so the Supreme Court actually reversed its ruling, overturning the state legislative maps, which may or may not have mooted out this case at the Supreme Court. We just don't know yet because the court hasn't ruled on it. But the court did ask for additional briefing in the case, asking whether the case is now moot because the new state Supreme Court had overturned the earlier state Supreme Court's ruling. You see why that would do that? And so I actually think that's a good way for the court to kind of dodge this issue entirely. I don't know if it will, but I think that would be a wise thing for the court to do. If it doesn't, here's why this matters. So this independent state legislature theory is going to apply to elections, right? Which would include any elections. We might think, for example, about the 2020 election. And we might think about some of the rules and regulations that state secretaries of state or state courts or other state authorities, not the state legislature, required states to follow in order to accommodate the irregularities of the 2020 election. Or maybe even a better example, the 2018 election with COVID, right? With COVID restrictions, how do you do voting? Well, state courts are saying you got to keep the election lines open. State secretaries of state are saying we're going to liberalize mail-in voting, right? These kinds of things. They're not legislative determinations. They're determinations by other arms of the state pursuant to legislation. But the legislature, under the independent state legislature theory, withholds for itself the power to unilaterally overrule any of that and make whatever rules that it likes, whatever rules that it likes for an election. Stunning, stunning, but more. The elections clause is not the only clause in the Constitution that deals with elections and the phrase the legislature. There's another clause. It's the electors clause. The electors clause provides for the appointments of electors in a presidential election, right? Maybe sounds familiar to you. Appointment of electors in a presidential election goes to the legislature. If you transpose that independent state legislature theory from the elections clause and put it on the electors clause, you can start to see the implications of this. You might remember in 2020 that then President Trump was literally calling on leaders in state legislatures in Michigan and Arizona and Wisconsin, Pennsylvania, Georgia, to overturn the results, the popular results in their state. That's independent state legislature. That's what it is. This was exactly the theory that the Trump team was following to overturn the election in 2020. If the Supreme Court were to adopt this, it would invite state legislatures to do whatever they want in the 2024 election. Now, I'll say in fairness, there are stronger versions and weaker versions of the theory. And if you want, I can describe a case from a few years ago where the Supreme Court rejected the independent state legislature theory. A very different Supreme Court rejected it, but nevertheless rejected it. Still, the signals coming from the court at oral argument is that if the case is not moot, it's likely to adopt some version of the independent state legislature theory. My worry is that if it adopts any version of the independent state legislature theory, that's going to be an open invitation to state legislators who are so motivated to do whatever they want with the election. Yeah.
So recently I read, and I'm not sure how correct this is about, is it Minnesota, sorry. Recently I read that Minnesota legislature, but I think they were posing a constitutional amendment to their constitution, I think, that said that the state electors would go to whoever wins the popular vote, even if the electors are, yeah. Is that right? Is that independent legislator? Or is that different?
That's going to pose an interesting twist, but I'll tell you that it won't matter for the hard version of the independent state legislature theory. And let me explain why. So the federal constitution under the supremacy clause is the supreme law of our land over any other federal law, any federal treaty, any state law, even any state constitution. And so for a state to adopt a constitutional provision like that would be as unconstitutional under the strong version of the independent state legislature theory as if the state adopted an amendment that said the state, for example, the state shall discriminate by race, which is plainly in violation of the federal constitution. Now, again, there are weaker versions that might account for that kind of thing, and the court might try to thread the needle and do that. But my worry is that in the context of the North Carolina case, they can't foresee every variation of a constitutional amendment or a super unamendable law in a state or whatever provision the state has. They're not going to be able to foresee it all. And that's going to leave an opening for anybody who is so motivated to go full throttle with an independent state legislature theory in 2024. I really worry about that.
Steve, I just have to stop you and say, I am so impressed, and I want to give you a round of applause for you making totally clear this complicated theory of independent state legislature theory. You have turned mud into clear water. So thank you so much.
Well, Barb, as usual, you're way, way too kind. And as usual, I've recorded your comments to take them home and play to my wife and kids. Yeah. Yeah, so that's where we stand. I think this is a case to watch. This could come down as early as tomorrow. The court's going to issue decisions tomorrow morning or next Thursday. It'll continue to, it's kind of behind the ball. It's got about 20 to go, but it'll issue decisions this week and the last few weeks in June, and then probably into early July. But this is a big one. This is a big one.
Steve, we did have a viewer online wanted you to specifically talk about the Water Act and some of the issues regarding the environment.
Let's do it. And here, I'm going to back up and give you a little context for this too, because we're seeing a move on the part of the Supreme Court that's affecting environmental regulation, but affecting the administrative state generally. And just to even kind of more broadly contextualize that, there's a kind of sustained, let's call it constitutional / political assault on the so-called fourth branch of government, the bureaucracy. That's been going on for a long, long time now, decades. That comes up in a variety of different sort of shades, colors, arguments, types. But what we're seeing is a Supreme Court that is moving sometimes incrementally, sometimes just in huge chunks, to accept these theories and diminish the role of executive agencies. Okay. One thing that just kind of on this point, one thing that I think we ought to be paying attention to, looping this back to the Trump discussion, is, one of the things that we're hearing in the public discourse is the Trump team saying that Biden's Justice Department is directing the prosecution, right? Well, I mean, that it's not only a grave error, I think that's a dangerous thing to say in a system where we have a history and tradition of independent prosecution by the Justice Department. It's not Biden's Justice Department, and it was never Trump's Justice Department. Whatever he said, it just doesn't work that way, right? Jeff Sessions, Bill Barr, They both resigned, got fired for holding that position. It just doesn't work that way. But this is wrapped up in that, right? And so this idea of a unitary executive, a unitary president who's in charge of the entire bureaucracy and can hire and fire people at will and direct the goings on in the bureaucracy, that's an idea that's gaining more and more traction in the Supreme Court. And again, it's manifesting itself in 100 different ways. It's almost like a death by 1,000 cuts. But one of the ways is in these doctrines that have come up in these two environmental cases, one last summer, one this summer. And so I'll describe them. Last summer, it was the Clean Air Act, West Virginia versus EPA, where the EPA had imposed what we call outside the fence line regulations on power plants, which means they were regulations on the air quality that power plants were releasing that would affect the plants themselves, but also beyond the plants. So cap and trade is an example of this, for example, because it affects the power plant's emissions and the way they deal with the emissions outside of the plant itself. And inside the fence line regulation would be something like air scrubbers that would clean the air as it's going into the environment. The West Virginia argued that EPA lacked authority to implement this under the Clean Air Act. The Supreme Court agreed, and in the course of that invented what they call the major questions doctrine. It works this way. If an administrative agency is going to make a rule or regulation, as EPA made the outside the fence line rule in the West Virginia case, if they're going to make a rule or regulation that has significant economic or political consequences, okay, then Congress has to be clear in giving the agency authority to do that. Now, what does it mean to be clear? We don't know. What does it mean to have significant political or economic consequences? We don't know that either. But we do know that the court used it to strike this EPA rule to regulate outside the fence line airborne emissions. Fast forward now to 2023 in the Sackett case, not the Clean Air Act, but the Clean Water Act, okay? Now, the Clean Water Act has long been a subject of litigation. The problem is this: it authorizes the EPA to regulate the waters of the United States. That's the language of the act, the waters of the United States. What does that mean? Well, it plainly means interstate waterways that are navigable for commerce. Everybody agrees on that. So the Mississippi River, right? Sure. Does it regulate tributaries? Does it regulate tributaries that are only in one state? Does it regulate tributaries that are non-navigable, right? In the Sackett case, the question wasn't a tributary. The question was, does it authorize the EPA to regulate wetlands that are adjacent to a water of the United States? The EPA said, we can regulate wetlands that are adjacent to a water of the United States. And the EPA said further, because of the way water works, right, we can regulate wetlands even if the connection to an interstate waterway is underground, right? Makes sense? Well, maybe it makes sense. It made sense to the EPA. And so the EPA denied a building permit for the Sacketts who wanted to improve their property by filling in a wetland that the EPA said was, again, language of the regulation, adjacent to an interstate waterway that the EPA plainly could regulate, but not on the surface. It was underground, okay? The Sacketts objected. They said that exceeds EPA's authority, and the Supreme Court agreed. What the Supreme Court said was that this adjacent to language means that the wetland has to be adjacent to an interstate waterway on the surface. There needs to be a surface connection, right? Rejecting the science at EPA, rejecting the fact that we all know that waterways connect, by aquifers underground, among other ways. Never mind any of that, that they have to appear to connect on the surface. And in the course of that, what the court said was, if Congress is going to give the EPA this kind of authority to regulate personal property or real property, personal real property, or what the court said, I thought this was interesting, to upset the federal state balance in regulating real property, then Congress has to do it with a clear statement. Again, a kind of clear statement rule, the same thing that we saw in EPA versus West Virginia versus EPA, but in a slightly different context. Here, it's got to be a clear statement to regulate something that upsets federal state relationships in regulating real property or in regulating real property itself. Now, again, the court didn't define exactly what this means, clear statement, right? Congress never legislates in clear statements unless it's in something like the tax code where you can, right? It's just not what Congress does. It leads all that work to the administrative agencies. And so these two new clear statement rules, one last year, one this year, are likely to have severe economic impacts. What it means is the federal government can no longer regulate outside the fence line under the Clean Air Act, and it can no longer regulate wetlands that aren't connected to an interstate waterway over land under the Clean Water Act, right? These are dramatic curtailments on EPA's authority, and that's going to have an effect on the environment. But think about what this means in the context of everything the federal government regulates and does, right? Literally everything. You can start to see how important this is and why this is just yet another iteration, another way that the court seems to be authorizing a kind of curtailment of the administrative state.
So water moves in many ways. It ebbs and flows through seasons based on rainfall. And I'm making more of a statement and out of frustration, because the science is really clear about the way water moves seasonally, and the rainfall and wetlands come and then they dissipate and then they come back. Is there any recognition that there's some real science that shows that to be true? Or are we just stuck in this world where it's the politics, it's the fight? I just don't understand how we can resolve this. Can you shed some light on that?
Well, I'll just start by saying that's way above my pay grade. No, I can't, but I can tell you what the court would say about it. I don't think the court is anti-science. I think it's got a peculiar view of how to determine science. And I'm saying this because in my head, I'm also thinking, I don't think the court is anti-history. I think it just has a peculiar way of viewing history. If we think back to the Dobbs decision last summer and the way the court used history, it's very much like the way the court's using science in these cases. What it's saying is, I mean, first off, I think if you were to give administer truth serum, I think the justices in the majority in these cases would say, well, the science doesn't really matter. We don't care about that because this is not a science question. But if they were to get to the science question, my guess is that what they would say is what the majority, what Justice Thomas said in the Bruin case, the gun rights case last term. And here I'll just remind you of the methodology. So the court in both the Dobbs case and the Bruin case, and apparently now in religious cases going forward, and potentially all other cases going forward, is going to use a historical approach, right? That looks to our histories and traditions to determine whether a government regulation is the kind of thing we've done before. If so, that makes it more likely to succeed. If not, that makes it more likely to fail. Okay. Or if a rights claim is something that we've acknowledged before in our country's history, if so, that makes it more likely to be an actual right. If not, it likely isn't. Now, there's a big problem with lawyers doing history. I'm a lawyer. I'm not a historian. I'll be the first to admit I know nothing about the historical method. The justices on the court equally know nothing about the historical method. Well, that doesn't bother the court. What the court said is, we're designed to litigate questions. And we can litigate history as well as we can litigate anything else. My guess is the court would say it could litigate science as well as it could litigate anything else in the same way. And so to the extent that it's dealing with scientific questions, I think it's just going to be who can pay the most for the best experts, frankly. In the same way that we're now in these gun rights litigation, we're seeing district court judges actually calling in outside experts on gun regulation history so that they can be true to the Bruin ruling from last summer. It's really stunning. Yeah.
Steve, we have 7 minutes left. So I don't know if you want to do some speed briefing or maybe quickly the 303 case.
I was going to say, I've mentioned that a couple of times. Maybe I could just run through that real quick. Is that okay? I'll be happy to I'm happy to stay all night if you like, but
I would love it, but they didn't bring their jammies. So I'm afraid we'll probably end as close to time as we can.
Okay.
But the 303
The
case is
303 case.
interesting.
Yeah, it is. And it goes with a trend of the court that I've kind of mentioned in passing here and there. The trend, just to be explicit about this, is expanding religious freedoms. And I think what we're likely to see in coming years and decades, given the court's rulings last summer and in the last 5 or 10 years, and the court's ruling likely in 303 Creative, is that religion is going to play a larger and larger part of our public life in ways that are sometimes surprising. 303 Creative is a great example of this. So here you've got a website designer who, as part of her job, designs wedding websites. And I think you can see what's coming here. She doesn't want to design custom wedding websites for any couple except one man and one woman getting married. And she's actually even said she won't design a custom wedding website for a divorced couple that wants to get married, right? This is all out of religious conviction, she says. What it means as a practical matter and as relevant to the case is that she won't design a custom website for gay and lesbian couples, right? Well, that's a problem because discrimination by sexual orientation and sexual identity violates Colorado's anti-discrimination law. So she would like to put up a website that says, I'm only serving couples that are comprised of one man and one woman, but she hasn't yet done that because she's afraid that if she does, she'll be prosecuted under state law for violating the discrimination provision. So instead, what she did was lodge a free speech claim that the Colorado anti-discrimination law violates free speech because it prohibits her from communicating the message that she wants to and requires her to create custom websites for gay and lesbian couples, right? It not only impedes her speech because she can't announce to the world that she won't serve gay and lesbian couples, but it also compels her speech, which is also a big free speech no-no. It compels her speech in the sense that a true application of it, she says, would require her to create these websites that she doesn't want to create. And so she's challenged it on free speech grounds. Now, it's an interesting way to do it. She hasn't challenged it on religious grounds. That came in a case called Masterpiece Cake Shop a few years ago. You might remember about the custom cake baker. She's challenged it on free speech grounds. My prediction is the court's going to rule in her favor. Now, there are a lot of reasons that have nothing to do with the merits, why the court shouldn't even touch the case. Remember, I told you she didn't even put up her website, much less get charged or prosecuted by Colorado authorities, right? This is all what we call pre-enforcement review, which ordinarily is not justiciable. But I do think the court's going to get to the merits in this case, and I think it's going to rule in her favor. And I think that's going to be just one more step in the direction of religious freedom and not only permitting, but requiring religion to be more and more a part of our public life. Now, I hope I say that in a neutral way. I certainly don't mean to disparage religion by saying it in that way, but I think that that's a distinct direction that we're seeing in the court's jurisprudence. And I think the logical end is something that we can all, whether we're religious or not, probably worry about. And so that's 303. Now, it has not come down yet. Again, that's a case that we could see as early as tomorrow. I actually don't expect to see it tomorrow. I think that's going to be a hard case for the court to write. And so it may come a little bit later, but it might be tomorrow. Yeah. Oh, can we do one question? Yeah, I'm sorry.
When Justice Alito wrote Dobbs, and he said that Roe v. Wade and its other abortion case were wrong. And he said they based their opinion analysis on the 14th Amendment. And he said when the 14th Amendment was adopted, the post-Civil War adoption, abortion was illegal in most states. What is wrong with that analysis?
So, well, how much time do you have? I'll tell you what I see as the most glaring error in that analysis. The most glaring error is that at the time of, at all the relevant time points that Alito considered in that ruling, abortion was indeed illegal in a good many jurisdictions, but with a hitch. After quickening. Okay. Now, quickening was the word that we, the people, used to determine when a baby was kicking or punching or whatever it does. Right. Now, what that suggests is not that abortion was illegal from the time of conception, but that we have a history and tradition of illegal abortions after quickening. Right. What that would mean in turn in today's medicine is that we have a history and tradition of regulating abortion after some point in the pregnancy where the fetus has developed to some degree, right? That's not what Dobbs came out with. Why? So you might say, well, so how does Alito justify a potential flat ban on all abortions? Here's how. What he said was the fact that states didn't prohibit abortion pre-quickening doesn't mean that they couldn't have. Yeah, true. Now, that sounds like kind of weird logic, doesn't it? It sounds even weirder when you think about the historical method in Bruin, the gun rights case, where the court explicitly rejected that way of thinking. In other words, in Bruin, what the court said was, yeah, we acknowledge that legislatures might have regulated guns in a particular way, but that they might have says nothing about what they did. We're looking at what they actually did. Stunning disconnect between the two historical methods. And I mean, we could go on it. We could talk all night about other issues with it, but I think that to me, that's the most glaring.
So thank you to Professor Steve Schwinn for providing us with an update on. You always make us smarter and wonkier, and we appreciate that. So we're so pleased you spent the evening with us. Also, thank you to our audience for joining us tonight, both here and online. And a big thank you to Wheaton Public Library and our sister leagues. And we hope to see you next month, Thursday, July 20th at 7 p.m. at Wheaton Public Library again, or online for our Civic Awareness Program. The co-chairs of the DuPage County Ad Hoc Affordable Housing Committee will present here at the library and online. We look forward to seeing you next month. Thank you and good night. That's all.